Afternoon, everybody. Hope you can all hear me okay. Well, I'm talking about possession claims, and what I'm talking about essentially is how you can try and stack the odds in your favour, try and make it a one-way bet at the end of the day in getting that possession of the premises. Sorry, a technical glitch here. Thanks. Now, property claims, as I said at the outset, are a vast area of law. And there's numerous textbooks written on the subject, and I'm sure you'll all be glad to know as time's pressing on, but all I'm going to talk today is very briefly about how a landlord can go about obtaining a possession order, and secondly, and just as importantly, how that order can be enforced at the end of the day. Now, this talk is simply very really based, keeping it straightforward and simple, on getting back possession of what's called assured short-term tenancies, or an AST, as it's commonly known in the trade. But all types of other sort of tenancies out there. There's old-style rent act tenancies, there's assured tenancies, so there's claims against squatters, against trespassers. There's also claims against commercial premises as well. And you'll be glad to know that I won't be touching on any of those today. And basically, what I want to try and do is just try and sort of raise sort of 5 key points, 5 key sort of pitfalls, I think, which often landlords come across when they're trying to get back possession. So pitfall 1, getting the right route. The first thing that you have to realise is, with very few exceptions, there's a legal requirement that a landlord obtains a court order to get back possession of a residential property. Self-help isn't allowed, and in fact, if you try and turf out the tenant yourself, it's very likely, I'm afraid, to be a criminal offence. So, the first headache to think about is that there are 2 main routes to get back possession. And I've described them here as the non-fault route and the fault route. Now, in fact, that's a very broad but inaccurate description. I've done it really to try and simplify the whole process. Looking first at what's called the non-fault route, and this is a route familiar to us all. It involves a landlord serving a termination notice, that's commonly called a Section 21 notice, on the tenant. Tried and tested, and it's generally regarded as the sort of standard way to get back possession of an AST. The second route I've called there, which is the inaccurate route, is what's called the fault route. And this is involve some sort of breach by the tenant, so the tenant's in default of the agreement. And in fact, I would add that some of the grounds which you can use for the so-called fault route don't involve any fault at all on the part of the tenant. There's 16 grounds potentially under this ground. 8 of them involve no fault at all. But they involve things like getting possession back from premises let to a minister of religion, vicar, you've got a vicar, student let, you've got a student let, and a fairly obvious one as well is where the landlord wants to revert the premises. In those sorts of situations, you don't have to prove fault. But essentially, with this route, the way it's worked in practice is that fault, or default by the tenant, is the way to get back possession. So I want to switch quickly and talk about a quick overview of the fault ground process. Starting point is the tenant needs to be in default. The tenant isn't in breach of a tenancy, is paying the rent, is complying with the tenancy, then you can't use this ground. Period. Simple. There are 4 sort of main fault areas which I've tried to flag up there. 3 involve essentially not paying rent, and the 4th involves sort of non-rent grounds and other breaches of the tenancy. Now, it's important to sort of look at, I think, at what these 4 grounds are in a bit more detail. The first and the most important ground is, which I'll talk to time and time again in the few minutes remaining, is called ground 8, significant arrears of rent. The second ground available to you in a rent case, tenant's not paying the rent, is minor rent arrears. And the third one is where there's delay in paying the rent. And finally, if the tenant is paying the rent, but is in some sort of other breach of the tenancies, sublet, for example, was not using the premises as a private home, then you've got ground 12 there available to you as well. Also, the tenant is committing a nuisance and annoying other people. That's actually confusingly a separate ground as well, but that would also be a breach of ground 12. So what do I mean by significant arrears of rent? Basically, standard AST, the rent's payable monthly, it means at least 2 months' arrears is outstanding. That is significant rent arrears. Minor rent arrears you use if there's less than 2 months. Delay in paying the rent is where there's a history of poor payment. Ground 12, as I said, basically covers kind of catch-all. It covers all the sort of other non-rent grounds. Now, one reason why ground 8 is so important, because I said on that slide there, it's what's called a mandatory ground for possession. This means that the landlord simply has to prove his case, prove the tenant owes 2 months arrears, and the court has got to make a possession order. This is extremely useful for the landlord, because of all the other grounds I've talked about, the other 3 grounds there, ground 10, ground 11, ground 12, the court has a discretion on whether or not it's going to make the possession order. It doesn't have to make the possession order at the starting point. The landlord has to jump through an additional hoop, and he has to show that it's reasonable for the court to make the possession order. And I'll give you a bit of guidance later as to how the court deals with this, what factors the court takes into account as to what's reasonable. There's also, finally, another problem with if you're using the discretionary grounds. And that is, at the end of the day, the court doesn't have to make an outright possession order. The holy grail, the name of the game, is to get what's called an outright possession order, which the landlord can enforce as quickly as possible. Using some of these grounds, 10, 11, 12, the landlord can make what's called a suspended possession order. And what that means is, provided the tenant complies with various conditions set out by the court, i.e. pays the arrears within a given timetable, keeps up the ongoing payments, then the tenant can stay put. So the landlord's gone to all the expense of obtaining a possession here, he got the possession order, but the tenant complies, he can't enforce it. So, at the end of the day, as I said, that's why ground 8 is so important. And any possession claim, based on arrears of rent, always try and use ground 8 if you can. And if you have to wait a month or wait 2 months in order to do it, my practical advice to you is to try and do it. So, what's the starting point? The starting point for the fault process is that the landlord, first of all, has to serve what's called a Section 8 notice before starting the claim. And I did bring one with me, which I was intending to wave at you, which seems to work quite well in cookery programmes. So not necessarily in large like this, but it basically shows what one of these notices looks like. And basically, all the landlord, it's a pro forma form, all the landlord has to do, or the landlord's lawyer, fill out the form, say what the breaches are, give some details as to what the grounds are, and most importantly, put a date in the notice as to when you're going to start your court case. Now, one of the issues we'll see in a moment with fault grounds is you have to give a minimum 2-week notice before starting your court case. Minimum 2 weeks. Give the tenant time to pay up, time to remedy the breach, time to stop the subletting. You've got 2 weeks to do it. If it doesn't do it in that time period, you can jump in and start the court case. You can't do it beforehand. And that's something important to remember with fault grounds. So, turning now to the next slide. Non-fault grounds, which basically, as I said, involves service of a Section 21 notice to terminate an assured short-term tenancy. On the face of it, much, much simpler. All the landlord has to do at some point is serve a notice to terminate the AST. Now, in practice, this is something of a minefield, and whilst there aren't any books written on the topic, I can assure you, landlord and tenant law, there's certainly chapters written on service of notices. Because the problem is, if a notice is defective, as we'll see how they can be in a moment, then the proceedings will fail and the landlord's back to square one. Now there's 2 stages when you serve a Section 21 notice, during the tenancy or after the tenancy. If you serve it during the tenancy, pretty straightforward. All you have to do is put in a date there which you make sure is not going to end before the fixed term tenancy comes to an end, and there's your date, done and dusted. The problems really start if you don't do that, and you leave it until after the fixed term has ended. Now then the reason why is you're relying on a slightly different section in the legislation. And the problems arise for 2 reasons. One, because the wording which a landlord has to use isn't entirely straightforward, and you need to really take that into account because you get the wording wrong, and the court's fairly wise done to this, they're aware of what the pitfalls are, what the problems are. The judge ain't going to make a possession order, I'm afraid. And the second reason is because special rules apply as regards the actual termination date in the notice. And you have to be aware of those rules and think about it, give it a bit of thought before you serve your notice. It's not difficult, it requires just a bit of thought, there might be a bit of delay, but you need to think about this before you jump in. But before starting the process, I mean, the non-fault route service of a Section 21 notice, it's always dependable. I mean, what are the pros and cons between the 2 routes, and what's the best route to actually follow? It all depends upon the circumstances. The tenant, the end of the tenant is back to where you serve your Section 21 notice. Tenant won't go, probably get on with the court proceedings, use Section 21. There's a number of advantages with that. First of all, you can avoid the need for a full-blown court hearing. It's a special procedure I'll talk about very briefly in a moment, called the Special Accelerated Procedure. This means you can avoid a full-blown court hearing. It is what I said, a mandatory ground for possession. That means the court must make a possession order. It's also quicker, it's cheaper, it's a kind of quick and cheerful route, so it's something which I think you always need to sort of bear about. But that said, I mean, service of a Section 21 notice in some cases does have disadvantages. Sorry, going back here. It's inflexible, it lacks flexibility. There's only one type of order you can seek on it. The only type of order you can seek is an order for possession. The tenant owes you arrears of rent as well, he owes you 6 months rent as well, you can't tack a money judgment onto that. All you can get is an order for possession. It's only available in certain undisputed cases, straightforward cases, so it's not really suitable for anything complicated. But that said, that can be an advantage because, as I'll talk about in a moment, with the fault route, there is ways the tenant can try and take in order to try and muddy the waters and stop the court making a possession order at the first hearing. And the tenant can't do that if you go down this route. So that's something you need to bear in mind. So looking now at the fault route, looking now at going down the route, the tenant owes you, tenant's in breach of contract, he owes you arrears of rent. I mean, what are the advantages of going down this particular route? I've highlighted some of them here. Sorry, there's some disadvantages there. And basically, the thing to think about it is it's more flexible. That's when you've got more grounds available to you. There's several grounds on which the landlord can get back possession, provided the tenant ticks those boxes and has defaulted and breached the tenancy, then you can use those grounds. You can use them all sorts of combinations. You don't have to specify one ground, you can use as many grounds as are available to you. And that's pretty useful with rent arrears. So I said you've got 3 grounds there. You've got the ground 8 ground, your principal ground, and you've got the 2 other grounds. You can't quite make that out. You've got persistent arrears of rent, you've got also minor arrears, and you could use these in combinations. This is quite a useful tactic, you'll find, when it comes to the court hearing. Also, the big difference with using the Section 21 notice is that you do need a court hearing, and there are disadvantages to that, which I'll come on to in a second. But there are advantages to this, so you can flush out potential defences. Also, you can iron out potential problems. It might well be some sort of hitch, some sort of hiccup in your case. The disadvantage of using the accelerated possession route, giving the papers to the judge, you don't have a court hearing. Any problems, the judge can look at it, make possession over here, and so you're back to square one. At least you have a possession order, turn up at court, explain the problem to the judge, you might well be able to overcome it. But, as with all things in life, I'm afraid there are pros and cons, there are disadvantages. And again, I've listed some of these here. I think the real disadvantage is the requirement for a formal court hearing. You need a hearing before the judge, so it's additional delay, additional expense. It's relatively easy for the tenant to drag out the claim, as we'll see in a moment. It's quite easy for the tenant to try and muddy the waters to stop the landlord obtaining a possession order. There's a minimum 2-week warning period noticed. Also, as I said, the mandatory grounds are limited. If you're going for fault, there's one mandatory ground available to you, ground 8, significant arrears of rent. If you can't make out that ground, the tenant doesn't owe you 2 months rent, you're always asking the court for discretion as to whether or not to make that possession order. And you've got that additional hurdle to try and overcome, and that's something you have to think about. So, and of course, at the end of the day, the tenant can always avoid possession simply by complying with the actual breaches. So, second, that's sort of as a sort of starting point, getting started. And the second pitfall is what to do about preparing the claim. I want to sort of get through this quite quickly, but I mean, as Carol was saying about the tenancy deposit schemes, you will have to tick a box and you have to in fact produce the documents to the court if you are trying using the termination notice, the non-fault route, and add all the documents to the court so the court can see if you complied with the tenancy deposit scheme requirements. Those haven't been met, you're not going to get a possession order. Check the notices are valid at the start of the process. Check the Section 21 notice is valid. Check the Section 8 notice is valid. Anything wrong with them, the proceedings are just going to fail there and there. Check the identity of the parties is correct. Amazing, but it happens quite a lot. You often see people who are parties to cases, people who have made a landlord to a case, who have nothing to do with the claim. I mean, they shouldn't be a party to it. It's crazy. But people are occasionally made parties to claims. Bizarre, but there are, it happens. Do ensure the correct court forms are being used. Possession claims are standardised forms. It's job really for your lawyers, but get them to make sure, when they're using the right forms. If they don't, that's a reason for the court not to make the possession order at the end of the day. It won't mean the claim will fail, but it will mean that delay and expense. And finally, do remember that the county court has exclusive jurisdiction in possession claims, in commercial claims as well. Your claim has to be brought in the local county court where the premises are situated, and you don't have any say over that. So if your county court's good, it's efficient, it runs well, fine. The reverse is true, tough, I'm afraid. So pitfall 3, the hearing. So now we come to the sort of main course, if I can call it that. As I said, all claims must be issued in the local county court. Where you're using the non-fault route, the service of a Section 21 notice, it's straightforward. The landlord can use a special procedure called an accelerated possession procedure and obtain a possession order without the formal court hearing. Provided the judge is okay with the papers, provided he thinks everything in order, then the judge has got no doubts the judge has to make the possession order. So it's quick and it's cheap and it's cheerful. The problem is any defect, and the court always resorts to striking out the claim. What often happens if the court does have an issue with it, what the judge is likely to do is list the claim for a formal hearing. Because what you have for fault claims, a standard possession hearing, is that the standard way of getting possession, unlike the debt claim, for example, is that the claim starts off by the possession claim being listed in what's called a possession list before a district judge. This involves a short hearing, usually 10-15 minutes. And basically at that hearing, the landlord has to be prepared to be able to prove his grounds at that hearing. And that means the landlord should be there, or the managing agent's got to be there to give evidence of any arrears. Evidence can be given orally at the hearing. It's also used by witness statements beforehand. Usually a good idea to serve witness statements beforehand, bring everything up to date. And to avoid the possession order being made, what a tenant's got to do, and the test for this, what the tenant has to do, is he has to show that each claim is genuinely disputed on grounds which appear to be substantial. And that's a test the court will apply in deciding whether to make a possession order. And in layman's terms, in plain English, what that really means is provided that the tenant can show that he's got some issue which requires further investigation, some issue of facts which the court has to look at, and that's a reason for the court not to make a possession order there and then. What happens then is the court won't throw out the claim. What happens is that the court's likely then to impose a timetable for progressing the case onto a full-blown trial. And that's bad news for the landlord, of course, because that means months of delay, additional expense, going to a court, full-blown trial, a day, 2 days. So always be prepared if you can to try and get the possession order at that first hearing, much, much quicker. Now, if a tenant wants to defend the claim, strictly speaking, it's meant to serve a defence within 14 days of getting the claim. In practice, I have to tell you now, that doesn't happen. What happens, the tenant usually waits till the court hearing, the day beforehand, or even turns up at court, and then produces his defence. So basically, the landlord's being ambushed. The problem is, there's very little sanctions the landlord can impose, or you can try and seek to try and prevent this happening. The easiest one, or the only real one you can do, is to turn around and say, well, we're all being dragged to court, we can sort this out beforehand, and try and get some sort of costs order against the tenant. That's the only one really available. Because the problem is with possession claims, as I was saying at the outset, you've got this short 10-15 minute hearing. So it's very easy for a tenant to try and muddy the waters, and he wants to just drag things out. This is in practice, this happens quite a lot. And the other thing to remember, as I was saying, it depends what grounds you are intending to use. If you're relying on any of these discretionary grounds, then you have to be able to make out those grounds at the hearing. You have to show to the judge why it's reasonable that you should be obtaining a possession order. And the sort of things you need to flag up: history of the arrears, level of the arrears, the steps you've taken, the dialogue you've had with the tenant. And these are points you need to deal with at court orally or in your witness statements. Try and persuade the court that it's reasonable to make a possession order at the hearing. So, pitfall 4. What many people forget is they simply think obtaining a possession order is a kind of holy grail. Once you've got that, you can enforce it straight away. I'm afraid that simply isn't quite correct. Because the aim of the game isn't just to obtain a possession order, it's to obtain an order which you can enforce as quickly as possible. That's basically known as, I call, an outright possession order. That's what you want. The alternative is what's called a suspended possession order. Now, this I was talking about. This is where the tenant can stay put, is allowed to stay provided he complies with the order. And usually this means paying off the rent and things like that. Provided he complies, the landlord can't enforce the order and he's stuck with the tenant. Or an outright possession order, usually enforceable after 14 days. 28 days, maximum 6 weeks in what's called cases of exceptional hardship. In case the tenant shows real suffering, it shouldn't be thrown out now on the streets now, then you can ask for 6 weeks. Suspended possession order could be suspended for months. I was doing one that was years, for 2 or 3 years. It's still there in place. There's nothing we can actually do about it. Provided the tenant complies, that's it. So I think at the end of the day, I think is always think about the mandatory grounds and why they're so useful to you. You can avoid all this happening. And for a landlord, obtaining an outright order is always the best option. I've got some figures here, some statistics which I've dragged up for 2012 from the Ministry of Justice, where up 42% of claims in 42% of possession orders in landlord and tenant claims, the court made a suspended order. 40% of those were enforced. That means in the majority of cases, the landlord didn't enforce the order. Now, I think I'll treat those figures a bit of suspicion, I think, because I couldn't get a breakdown of private landlord claims as opposed to council claims. And I think these have been slightly slanted with the council claims, where you have a lot of these sort of suspended possession orders being made. But it does show the extent to which the court are prepared to make these possession orders, or what you can do to try and avoid it. Finally, parties can't agree a consent order. If the tenant says, I'm going to go, I've had enough, I'm off, landlord can't simply turn up, produce an order by the court, signed by the parties, say, by consent, please make the order. Possession claims doesn't work. All you can do as a tenant is turn around and say, well, please in no circumstances don't take any steps to defend the claim. That means that the landlord still turn up at court and persuade the court to make the possession order. It should be relatively straightforward. So, turning now onto the sort of the last course, so as to speak. You've got your possession order, you can enforce it, how are you going to enforce it? Many people often make the mistake of thinking, well, they can simply do it themselves. Not quite, well, not true, I'm afraid. There's 2 ways that you can do it. County Court bailiff, standard way in the County Court, or a newer process called a High Court Enforcement Officer. County Court bailiff, cheap and cheerful. Costs £110 to issue your possession warrant, that's a starting point, and then the bailiff will then fix a date and enforce the order for you. The problem is, I'm afraid, all things quick and cheerful, I'm afraid it takes time. And it can take weeks to obtain a possession order, which means, of course, that the tenant is still in place, usually not paying you any rent. You might have an order requiring to pay rent, but you cheerfully ignores it. And so it can take weeks to obtain a possession order, because the sort of bailiff potentially works on sort of bug in his turn, really, I suppose. Far better way to try and do it is what's called a High Court Enforcement Officer. Transfer the case to the High Court for enforcement. Then you can use these people who are like old-style county court, old-style sheriffs. You can do it in days, not weeks, and it's not that much more expensive either. Great. Downside is you need to persuade the county court to do it. County courts will generally do it in cases of trespass, where you've got squatter in there, or some squatting. County court doesn't have a problem doing that. Does have a problem with regard to enforcing a standard possession order. The court has a discretion on whether or not to transfer it. And generally, the court's approach is to exercise its discretion in favour of keeping it in the county court. Whether that's for their invested interest to give jobs to bailiffs, I don't know. But that's the way in which the courts are approaching it. Finally, end of the day, all isn't quite lost for the tenant. Landlord's got his possession order, about to enforce it. The tenant can still turn up at the last minute and try and freeze the enforcement process by making an application for an application to suspend a warrant of possession. Good news for the landlord is that unless there's some really sort of drastic change in circumstances since possession hearing, the tenant ain't going to succeed. But it does happen, it's time consuming, and it can throw a spanner into the process. So, summarise very quickly at the end of it, always use mandatory grounds when you can. It is relatively easy to obtain a possession order, which can be enforced quickly by using the right route. Be prepared, have a clear idea of your strategy, and it's much easier to get the sort of order you want. Discretionary grounds, I've talked about, can be a double whammy. Far more complicated to get the order, and worse news, far more complicated to enforce as well. Good news is the courts are prepared to make possession orders and have a fairly robust attitude towards enforcement. So that, in a nutshell, is a very, very, very quick guide to possession claims. Thank you very much.